We are scheduled for a motions hearing. Let's see. It really is sort of a motion in limine type of issue in terms of the extent of evidence that can be submitted that was previously submitted in the Texas courts. And Ms. Gehring is somewhat new, not as new as she was previously, obviously, but she needed time to examine the case and the Texas situation in order to evaluate what she believed was relevant and necessary from the Texas case. And there's a legal argument with regard to whether or not the court can find some basis for estoppel or res judicata or anything of that nature.
The court session begins with a judge explaining that the hearing has been scheduled to address several motions related to the case. The main issue concerns what evidence from earlier proceedings in Texas may be presented in the current Kansas court case. The judge explains that attorney Ms. Gehring is still relatively new to the case and needed time to carefully review the details of the Texas proceedings. She wanted to determine which parts of that earlier case might still be relevant and necessary for the current matter. The court also notes that there are legal questions about whether the prior Texas case could prevent certain issues from being argued again in Kansas. This raises concepts like legal preclusion and whether some matters should not be relitigated. In addition, another issue involves depositions and whether parties must appear in person or can participate by video. Because several questions remain unresolved, the judge invites Ms. Gehring to explain her position and outline what matters need to be addressed by the court.
To suggest that these matters shouldn't be fully relitigated in Kansas. And then additionally, there was an issue with depositions and in-person appearances. And I don't know if that's been resolved or not. So, Ms. Gehring, I'll let you apprise the court as to what needs to be heard in your view and who has the burden and what you intend to establish this morning.
Your Honor, we do not have agreements on the depositions. We don't even have dates. And so, Your Honor, I think that needs to be decided today, how we're going to do the deposition of my client. I cannot get the petitioner to agree. Agree to a date, and then she won't agree if we don't get a date for my client, but then we can't agree on whether it will be in person or by video. So we need to determine, I guess, one, if my client can appear by video. I believe the burden is on the petitioner. It's her motion and her request that he have to appear in person. You know, I believe our request is that my client be able to appear by video. I set forth in my response that was filed yesterday the law that allows that. It's under, I don't know if you want me to go ahead and argue, if you just want me to answer what I think the issues are. Then the next issue, Your Honor, is whether or not they can limit discovery. I think that needs to be heard also. Mom is trying to limit what we can do in discovery, which, Your Honor, I think this is premature. I think we should be able to conduct discovery fully.
Judge,
after discovery.
Judge, this is my motion, and I feel like, I mean, she's arguing her motion.
Okay, that's fine. That's fine. All right. Go ahead and argue your motion.
All right. What I wanted to say first,
but I thought I had said previously, discover, when we continued the case and sort of reopened discovery, I thought what I said is discover whatever you want, but that doesn't mean that you're going to be able to admit it in trial.
You did say that, Judge.
Advise yourself as broadly as you need to focus on, you know, what you think is important to establish at the trial with the time that you have to do it. Go ahead and explore it all, but that does not mean that the court's going to necessarily hear it all. But okay, so I'm Ms. Huntington, please argue your motions.
Okay, Judge, what I wanted to say at the outset is After much discussion,
Ms. Gehring begins by explaining that the parties have not yet reached an agreement regarding depositions. According to her, they have not even been able to set specific dates for them. She believes this matter needs to be resolved immediately so both sides can properly prepare for trial. One key disagreement involves whether her client must appear in person for the deposition or whether appearing by video should be allowed. She argues that the burden of proof should fall on the petitioner because the petitioner is the one requesting that her client appear physically. Ms. Gehring maintains that the law allows her client to participate through video, and she included those legal arguments in a response filed the previous day. She also raises another concern, stating that the opposing side is attempting to limit the scope of discovery. In her view, it is too early in the process to restrict discovery because the attorney should first be allowed to gather all relevant information before deciding what evidence may ultimately be used.
with my client, we are withdrawing our motion for him to appear in person for his deposition. In fact, we don't believe we have time at this point because we've not been able to agree on dates to get those done and appear for trial on time. We have trial set the 1st of April. And so we are withdrawing, taking his discovery deposition altogether.
Okay.
So my only motion,
You're gonna take it, you want to take his deposition, but you don't want to, but you don't.
no, I'm not even going to take a discovery deposition.
Okay, all right.
And with regard to the motion on limiting the scope and duration, Judge, without belaboring the whole thing, it's what is proportional to the needs of this case and what is impacting the child's life at this point. Spending time in a deposition, I have no idea if counsel is wanting 6 hours, 8 hours to spend with my client, badgering her and berating her about things that happened 20 years ago. Judge, I just don't think that that meets the needs of this case. It caused unnecessary expense. These parties have argued those same things in Texas and ended up with agreements. They had an amicus attorney make an arbitration decision. All these things have already been discussed. They're not impacting the child at this time. There are no allegations of anything currently going on with regard to these allegations in the pretrial of my client alienates the child, is erratic, drinks alcohol. That is what I'm trying to avoid, Judge, is delving into things that happened years ago. My understanding is the respondent has a criminal history, but we're not interested in delving into that because it's not relevant and material to what Your Honor has to decide in this case. And that is what is in the child's best interest based on all the facts of what is happening to the child at this point. So all we're really asking for, Judge, is maybe just an admonition. Let's keep our eye on the ball here. What are we trying to do? Do we need to go back over these things from 20 years ago? And then some sort of limit on how many hours my client has to sit and appear for a discovery deposition that is probably 2 weeks before trial. And she'll turn around and testify again at trial. Judge, I will close on that. And I mean, that's all we're asking for. I think the court has the authority under KSA 6226 B and C to protect, if you will, provide some protective orders to limit the scope of discovery if it's just cumulative harassment or has no purpose to get us to a resolution in the matter that's.
During this exchange, the opposing attorney briefly interrupts, noting that the motion currently being discussed is actually hers. The judge acknowledges the interruption and allows the attorney to proceed with her argument. The judge also clarifies something he had said earlier when the case was continued and discovery was reopened. He reminds both sides that he encouraged them to explore any information they believed necessary during discovery. However, he emphasizes that gathering information does not automatically mean all of it will be admitted during the trial. Attorneys may investigate widely in order to prepare their case, but the court ultimately decides which evidence is relevant and admissible. The judge encourages both sides to focus their preparation on what they believe is important for trial, while keeping in mind that not every piece of information discovered will necessarily be presented before the court.
Thank you, Judge.
All right. So Ms. Gehring, it sounds like you can skip over, the personal appearance for deposition.
Thank you, Your Honor. The frustration I have with this is this is the first time I'm hearing that by counsel, and we have been trying for over a month to get a deposition scheduled for her client, and then they keep saying, "Well, they tell Your Honor, we don't think depositions are necessary." I've heard that by counsel multiple times, but if you're going to take my client's deposition, then I'm going to take your client's deposition, and I want your client to appear in person, even though we don't think they're necessary. So it's been this long fight about this. And I can't ever get counsel to agree to a date. And now that we're a month out and probably going to have a difficult time finding dates because they haven't agreed, and now it puts me in a position. Now they're trying to push to go to trial, but now at the last minute, we don't need a deposition. But so I'm really concerned about the ability now to try to find a date, because had counsel told me this before, we had planned, Your Honor, from the last hearing. I had asked counsel, we were set for trial on today and tomorrow, so let's do your client's deposition on Friday. And she says, well, I'll agree to that, but then it has to be stipulated, well, then your client has to come in person and have his done. So all along it's been, we had that date suggested, but now, Your Honor, I still would like to do that. I don't even know if I can get a stenographer available tomorrow to do that. But now then we've got spring break, and we've got to try to find, which I'm out of the office, a date to do this. So I really feel like, I don't know if this was done intentionally or what the purpose of it is, but it feels like to me, Your Honor, had this been figured out and communicated earlier, we could have got a date. Now I'm concerned we're not going to be able to get a date. So I think we need to figure that out today, Your Honor, for the petitioner's deposition. Your Honor, regarding this motion limine, Your Honor, there has never been a trial on any of the issues in this case. And that's what I don't think the court has the ability at this point to say we're gonna cut off discovery and limit it to this when there's never been a trial. And I think under Kansas law, the court has to, it's what's in the best interest of the children when there's been no evidentiary hearing. So counsel that keeps saying, well, in Texas, there was this, that, and the other, there was never a trial. There was never, and the case was dismissed. So, Your Honor, I don't think you're bound by anything in Texas when that case was dismissed. Furthermore, Your Honor, I think for the court to get a full picture of everything that's going on, you have to have somewhat of a historical view on what's happened and how that may affect the child. The court can determine at the time of trial whether or not things are relevant for purposes of that hearing. But Your Honor, to come in and say right now on before we even go to trial, you can't ask any of these questions because we think they're too remote in time. Your Honor, that's not for the petitioner to decide. It's for the court to decide at the time of trial whether it's relevant. And Your Honor, we under KSA 6226, we can do discovery into anything that's relevant to a party's claim or defense. So that's a broad scope, and they can't come in and limit it just because, Your Honor, I think what they're trying to do is they are concerned about what we're going to get into historically with the petitioner, and they want to try to keep it out on the outset. We are entitled to do discovery on it. She can make her objections during the deposition. Her client can answer them. And then at the time of the trial, Your Honor can make a determination of whether or not the court wants to hear that and whether it's relevant to what's going on in the case. But Your Honor, we should be permitted.
The opposing attorney, Ms. Huntington, then addresses the court and announces an important change in her client's position. After discussing the situation with her client, she explains that they're withdrawing their earlier motion requesting that the opposing party appear in person for his deposition. She explains that time constraints are now becoming a serious problem because the parties have not been able to agree on dates. With the trial scheduled for early April, she believes there is no longer enough time to complete that deposition properly. As a result, her side has decided not to take the deposition at all. The judge seeks clarification, making sure that she truly means they will not pursue the deposition anymore. Ms. Huntington confirms that they are dropping the request entirely.
To do discovery. Your Honor, it's my understanding there haven't been any depositions done in Texas. There was no hearings done on the merits in Texas. It was arbitration. It was mediation. It was all this different stuff. There was never a trial before the court. So, Your Honor, my client's entitled to his day in court. I set forth the law, Your Honor. I don't think under 6226 that there's a basis to limit the discovery at this time. And Your Honor, I truthfully think it's going to get this case in a position if the court prematurely limits discovery, the ability for an appeal if my client doesn't get the ability to fully do discovery to when he's never had a trial, and to prepare. And then, Your Honor, if the court does that prematurely without the ability to even discover some of this information, it's really limiting what my client can do at trial. I'm also concerned, Your Honor, I can't imagine that the petitioner isn't going to go historically back into some of this. And then how do you determine what history we're going to allow in and what we're not? Because what they want to do is allow in what they want and exclude what's harmful to their client. So, Your Honor, I think at this point the court should not limit the discovery, and allow us to fully do discovery. They can lodge their objections throughout the deposition. She can answer the questions, and then at the time of trial, we can determine whether or not it should be admitted or not. But, Your Honor, I think at this point it's premature. I also think, Your Honor, after the discovery is completed, if she wants to file a motion in limine at that time prior to trial, after we've done discovery, maybe that's a more appropriate time to do that right prior to trial. But, Your Honor, I think at this point, the motion should be denied.
Okay. Ms. Huntington, can you and your client be available for deposition tomorrow?
I cannot.
Ms. Huntington then moves on to the remaining issue regarding limitations on discovery. She explains that her concern is whether the discovery process is proportional to the actual needs of the case and the well-being of the child involved. According to her, the opposing counsel may intend to spend many hours questioning her client about events that occurred decades ago. She argues that such questioning would be unnecessary and would create extra costs and emotional stress for everyone involved. She points out that many of these issues were previously discussed during proceedings in Texas, where the parties ultimately reached agreements. Since there are currently no allegations that the earlier issues are affecting the child's present life, she believes revisiting them would serve little purpose.
I advised counsel a week or 10 days ago, right after the hearing, that a PFA special setting got set that morning. I advised her of this fact. I'm not trying to, I'll find a date for my client. I also advised her that we needed to get her client scheduled because I will be out of the country for a week. And she kept poo-pooing it, saying, well, we don't know if it's going to be in person or not.
Okay.
And so that's
I'm not going to lay blame anywhere with the lack of depositions being scheduled at this point. I did not look at this case that you cited, Ms. Gehring, but I have a feeling that's a deposition of a witness, not a party. I'm concerned that civilly speaking, under civil procedure, I believe parties have to appear within the state that they filed a suit, or within a state where they're a party, in person, frankly. And I don't know that statute's caught up with the Supreme Court rule and the ability to Zoom and all of that kind of thing. But at any rate, they've withdrawn that. So I don't need to belabor how he needs to appear in person or by video or otherwise. But let's move to the other issue. I do believe you have a right to depose the plaintiff in this matter. I do, again, if I didn't say it before, believe as an attorney who advocates and prepares and advises that you do have a right to full discovery, protective orders perhaps on medical or private things and things that may be totally unrelated to anything related to marriage or parenting. But at any rate, I think you're allowed discovery. I expect Ms. Huntington to make contemporaneous objections to anything that she thinks is objectionable, including
Continuing her argument, Ms. Huntington says that the court should focus on what is truly relevant to the child's best interest today. She explains that there are claims suggesting her client has behaved erratically, alienated the child from the other parent, or struggled with alcohol use. However, she believes the opposing side wants to reopen very old matters simply to attack her client's character. She argues that such questioning would be more like harassment than legitimate discovery. Therefore, she asks the judge to provide guidance or limits so the deposition does not become an extended attempt to pressure or intimidate her client.
relevance. I would ask that you try to find a real-time court reporter so that there can be a transcript so that those things can be noted by the court during our trial, if at all possible. I assume that Ms. Gehring, you pay for the court reporter, you pay for the transcript, and
Yes.
I don't think there's a party witness fee. I'm not sure whether your client gets anything or not for that. I'm not going to give a time frame. I don't think there's anything statutorily that suggests that I can do that. What I am going to say is if it becomes pure badgering and it's clear that it's badgering and psychologically impacting your client for whatever reason, that, once you've hit that 3-hour mark, you can call my office and ask to have a ruling from the court as to any extension of that deposition. But I'm not going to say it's restricted to 3 hours or it's restricted to 4 hours, but I will.
Ms. Gehring responds by expressing frustration with how the deposition issue has been handled. She says this is the first time she has heard that the other side intends to withdraw the deposition request. For more than a month, she says she has tried to schedule depositions, but could not get clear agreements on dates. She explains that the opposing counsel repeatedly suggested depositions might not be necessary, yet still insisted that if one party was deposed, the other must also appear. Because of these delays, she is now worried that there may not be enough time left to arrange a proper deposition before trial. She believes the sudden change in position has placed her client in a difficult situation.
Allow you, if there becomes a point in which you believe there's extreme badgering and it's quite apparent that it's for purposes of not just rattling your client, but psychologically impacting her, then you can call me and I will take it up with counsel at the time. But otherwise, just make your objections, try to get a record. I need you to agree on a date right now before we go off the record.
I can start Wednesday, the 11th at 1 o'clock.
I have a court hearing that day, so I can at 2 o'clock in person. I guess it's not in person, but it's by Zoom. But
is there something you could move or have somebody cover? I would really like it to be within the week, if at all possible, especially if you're going to be gone during spring break.
I think I could do the morning of March 12th.
I can do that.
Okay.
Veronica, can you make that work? Okay.
She's shaking her head yes.
Yeah.
Where are you doing the deposition?
Yeah, sorry.
We can do it at my office.
Is that all right with you, Miss Huntington?
I don't usually prefer that. Can we do it are you going to use Kelly court reporting? Could we just do it over there?
Ms. Gehring then addresses the argument about limiting discovery. She insists that there has never been a full trial on these issues, either in Texas or anywhere else. According to her, the Texas proceedings ended without a full evidentiary hearing and were eventually dismissed. Because of that, She believes the Kansas court is not legally bound by anything that happened there. She argues that the judge should allow both sides to fully investigate the facts before deciding what evidence will matter. In her view, understanding the history of a case may help explain current circumstances and could affect decisions about the child's welfare.
I also have to make sure I can get a court reporter.
I-
I've never done it in a court reporter's office. I mean, we usually just do it in my conference room here.
Well, I think probably, I think if I were attorney to attorney, that I'd want my client in my office, just like you'd want your client in your office. So there isn't, just a sheer intimidation factor just because you're off soil. I mean,
We can do it here. That's fine.
do you have the space and
I
the
do.
ability?
Yeah.
Okay, well, let's have it done at your office at 9 a.m. then. And if you need to start a little earlier or a little later or whatever you need to do with the court reporter.
And Judge, you will be in available that
Uh,
day?
Yeah,
We
let
need
me look here. Amy always responds to emails, even when we're in court. I have a Greenwood docket. I'm in Eureka in the morning. And then I have some Zoom hearings in the afternoon. It's all Greenwood Elk stuff. But I will stop whatever I'm doing and listen to your objections and arguments if it's needed. So,
Okay, so Amy will be with you in Eureka?
yes. I
Okay.
think she plans to go. Amy, do you plan to go this time?
Yes, I will be over there.
She further explains that discovery rules generally allow attorneys to request information that might be relevant to a party's claims or defenses. She believes the opposing side wants to block certain historical topics because they may reflect poorly on their client. However, she argues that those issues should not be excluded before discovery even takes place. Instead, the proper time to decide whether the information is relevant is during the trial itself. At that stage, the judge can evaluate each piece of evidence and determine whether it should be admitted.
Okay, yeah. And
Thank
we
you.
can give you that direct telephone number too, in case you're not catching her attention by email.
Okay.
All right, anything further today?
Not from the petitioner, Judge.
Do we need to set a pretrial for a motion in limine, or are we just gonna do this during trial?
I'm fine to do it the morning of trial if counsel's okay with that.
Well, I don't want to spend a lot of time in motions the morning of trial.
Okay, all right, then,
I
yeah.
don't mind doing it throughout the trial as questions are asked, but, we got 2 days. I want to get the case done. I think we're going to need the full 2 days, frankly. What does your schedule look like, March 27th at 9 o'clock?
I have another PFA trial.
Okay. What about Monday, the 23rd at 3 o'clock?
Sorry, Judge, that's me again. I'm out of the country until the
Oh.
25th.
Okay. Well, then
The 30th, 31st, I have time. I don't know if that's an option.
I have a PFA trial and it's scheduled all day live and I'm not sure why. Usually,
Judge, is that March 31st, you said?
yes.
That trial is off the calendar. They've reached an agreement, but I have you out of the office as of 3:30 that day.
Yeah.
So you are available from 9 to 2.
Does 31st work for you, Ms. Garing?
Yeah, I have a hearing in the morning at 11, so I can do it.
Ms. Gehring also warns that limiting discovery too early could create legal problems later. If her client is prevented from gathering evidence that might support his case, it could become grounds for an appeal. She emphasizes that her client has never had a full opportunity to present his case in court. Therefore, he deserves a fair chance to collect information and prepare for trial. She concludes by suggesting that if the opposing side still wants to limit evidence, they should file a motion after discovery is completed rather than before it even begins.
Any other time, probably. I don't know if we can do it like 1 or something like that.
Well, yes, let's just, Ms. Huntington, does 1 o'clock on the 31st work for you?
Yes.
Okay.
Is she filing a new motion then?
She may after the deposition. It's to hear any pretrial motions that you filed. And I want them filed no later than the 27th.
Okay. Will that be Zoom, Judge?
Yes.
Thank you.
So if nobody files anything, then do you just want us to, do we still appear, or
No,
we just maybe get in contact and figure, okay. Just only if a new motion's filed, then I take it?
Yeah.
Okay,
only if pretrial motions, like a motion in limine. A motion to
Okay.
compel is not a pretrial motion. It's a discovery motion. So, yeah, I mean, something's going to have to be filed that you
Okay.
want heard prior to trial that is a legal question or, some kind of evidentiary question,
Okay.
whether it's
And
relevant
Judge,
or otherwise.
Judge, you said you wanted them filed by 5 o'clock on the 27th.
Yes.
Okay, so I can track that too and reach out to counsel. And if we don't have anything filed, I'll reach out to him Monday.
that'd be great. Thank you.
Okay. All right. Good luck, everyone.
Finally, the judge confirms that his staff will remain available in case disputes arise during the deposition. He assures the attorneys that if they need a quick ruling, they can contact the court, and he will review the issue even if he is handling other hearings that day. Before ending the session, the attorneys briefly discuss whether any additional pretrial motions will be scheduled. The judge suggests that certain issues may simply be addressed during the trial itself rather than holding another separate hearing. With those matters settled, the court prepares to move forward toward the upcoming trial date.